Ms. Hong is pro bono?
Yes, Your Honor.
I've seen you before.
Yes, Your Honor, I've seen you.
Indeed.
It's always a pleasure.
Thank you.
Well, good morning. May it please the Court. My name is Kari Hong. My co-counsel is Laura St. John. We are from the Florence Project. We represent Mr. Jose Alcocer Vargas. I will reserve 2 minutes of my time for rebuttal. I will watch the time.
Very well.
This case appears like a complicated chemistry issue, but in reality, it involves a simple legal question that this Court can and is compelled to easily answer. We have had an evidentiary hearing. Everything that the Court needs to resolve this issue is in the record.
So you just view this as a failure of proof by the government, right?
I'm sorry, what's that?
You just view this as a failure of proof by the government.
I see it as a legal issue, a number of legal issues that both other circuits and even the BIA itself and Felix Figueroa have resolved in Mr. Alcocer's favor. Starting with the federal analogs, the DeCampo footnote was incorrect to suggest that the Federal Analog Act captures every drug that is not listed on the Controlled Substance Act known as the CSA. A federal analog is a term of art. It has two elements. The analog has to have a similar chemical structure, and it has to have a similar pharmacological effect as a CSA drug.
But in this case, counsel, you may be an expert in these isomers. I was learning a lot reading about this, and I still don't know as much as I need to know, but it seems to me that no court in this proceeding has actually analyzed the impact on the body of the isomers involved. Basically, we have no record. Your client brought it up before the IJ. It was never contested by the government. The government didn't talk about it before the BIA. So we really don't have a record. So what you're asking us to do is just based on chemical descriptions, that's it. There's no an analysis of how this works or the paraphernalia related to methamphetamine. Is that your position?
My position is the one shared by the Seventh Circuit, precisely on methamphetamine, and 6 other circuits. It's not about chemistry, it's about statutes.
But the statute in Indiana was different than this one.
It also regulated optical and positional isomers. Arizona regulates optical and positional isomers. And what's significant, the Felix Figueroa case from 2015, it's cited in the supplemental brief. It's a published case from the BIA. Footnote 1 says that the DHS and the pro se party agreed that positional isomers exist. Footnote 2 is significant because footnote 2 cites to the 2nd, the 7th, and the 8th and says under those circuits, our case would be done because the statutory overbreath is enough.
So your argument is the fact that positional isomers exist is a legal matter that we could resolve?
Well, once positional isomers exist, then Lopez Aguilar in the Ninth Circuit says statutory overbreath is enough.
Okay, well, answer the first question, though.
Yes, well, it has been resolved by the DHS and the BIA at this point, and the Seventh Circuit, that positional isomers exist. And on this record—
But as a legal matter, we have to accept that legal isomers exist.
Yes, and we had an expert declaration in this record, which is found at 276. The Seventh Circuit had a footnote—
What do we do with the Chenery line of cases that says that, us courts cannot substitute the judgment of agencies? Since the BIA never found this question, how are we supposed to do that?
Well, under the BIA decision, they recognize that only CSA substances at number 3 are those that can trigger deportability. Now, what the BIA did is that it analyzed geometric isomers, which is an argument that Mr. Alcocer never advanced.
So the BIA never found positional isomers, correct?
Well, not in that case, but in the published case from 2015, footnote 1, the BIA says, yes, positional isomers exist. We have the record that exists. The DHS does not dispute it, either in the BIA, it never disputed it. At the immigration court level, it never disputed it. And in this court, it does not dispute it.
Is that binding, that old BIA position, is that binding on the panel that's in this case?
Well, yes, it is. And also we have the Seventh Circuit recognizing.
That's not binding at all.
Well, Lopez Aguilar said that if you just look at the statutory text alone, as long as it's not a logical impossibility, that will be enough. And Lopez Aguilar addressed whether a robbery by consensual taking would be overbroad to the generic offense.
So that's only the first question. The second question, as a factual matter that I see it, is whether or not positional isomers have a potential for abuse. And how are we supposed to find that as a matter of law, that that's true?
That's a factual question that no one has ever asked. The BIA has never addressed it in any decision, this case or any others.
So how are we supposed to do that?
Because all you have to do is go affirm what the Ninth Circuit says, that if there's statutory overbreath, that alone is enough to meet that is enough to show overbreath, and then under the deportability context, it's also indivisible.
You know very well, given your experience, we deal with categorical analysis and modified categorical analysis in so many ways, in so many settings. But this one's different. This one's different because we're talking about chemical compounds, very significant scientific issues, and nobody really analyzed what the impact was on the body. And, of course, part of what the statutes deal with here is the impact on the body. I share what I believe my colleague's concern is this is a serious issue, but we're not scientists. Certainly I'm not. Maybe my colleague from Texas is because he has an engineering degree, but I'm not a scientist. I don't purport to be able to analyze the technical aspect of it, and I don't think I'm supposed to be doing that. I think it's supposed to be done by experts in a hearing so they can determine whether, in fact, there is a categorical match. If not, whether it's a modified because it's divisible. I don't see how we can do that. How can we?
Well, the immigration courts surely cannot.
They can do fact-finding.
Well, Dana Marks noted that an immigration court is traffic court for the death penalty. These are three...
What did you call it?
What's that?
What did you call it?
The traffic court for the death penalty. These are 3-hour hearings. The federal rules do not apply. They do not have to apply at all, which is why the Seventh Circuit, the Eighth Circuit, the Second Circuit, the 11th Circuit, and the Third Circuit have all said we look at the text. If the statutes for drug offenses, if they're overbroad to the federal definition of what's in the CISA, our work is done.
But it's your contention that one can do that, as my colleague referred, as a matter of law. You can simply look at the isomers involved and you can say, oh, that's overbroad.
That is what Malui does. That is what Moncrief does. That is what, in the citation of the opening reply and supplemental brief of what the Six Circuits do, they simply say, we look at the statute. We do not need to look at anything else. And that is the province of the courts.
Can I interrupt you and make sure, do you accept that this court's jurisdiction is limited to questions of law as opposed to questions of fact?
Yes, the court also has jurisdiction of application of law to fact.
Okay. And so let me walk through my reading of what the BIA did and tell me where you think it made a mistake of law. First, it looked at the statute of conviction, Arizona Revised Statute 133415A, and found that it was overbroad because it included several substances that are not federal. You agree that was correct?
Of which statute?
Arizona Revised Statute 133415A, the statute of conviction. You agree that BIA correctly found that overbroad.
So that conviction is actually drug paraphernalia because he was caught with a baggie and there was some residue on it.
Right, but the definition of dangerous drug
is at a different
is broader.
It's not 3415A. It's a different statute.
Okay, fair enough. But we're concerned here with the definition of the term dangerous drug.
Correct.
Right. That's what makes it overbroad.
Correct.
Okay. And so then the BIA looked at the Shepard documents and found that they narrowed the basis of your client's conviction to methamphetamine. And was that an error of law?
Yes, because what they did, they said they started before by saying we look at the overbreath, and they said because geometric isomers do not exist, citing to the Ninth Circuit case, they said then this is not overbroad.
Well, okay, but the statute defining the types of drugs that can underlie a paraphernalia conviction included narcotic drugs, dangerous drugs, marijuana, or peyote.
Correct.
And that's what made it overbroad.
And because dangerous drugs includes methamphetamine. And the BIA's error is that they said, well, geometric isomers don't exist. They ignored that positional isomers.
Well, I guess what I'm
do
asking
exist.
is what did the BIA do wrong in looking at the Shepard documents and saying, it didn't say this, but it said the Shepard documents narrow the basis of your client's conviction to methamphetamine. And true, it didn't address positional isomers, but is that an error of law given that positional isomers were never mentioned in the Shepard documents?
Yes, because he raised it to he had an expert opinion, he raised it to the IJ, he raised
Right,
it
but
to
you
the
could
BIA.
you could have an expert opinion that tons of drugs exist, but the Shepard documents narrowed your client's basis of conviction to methamphetamine.
Yes, but
and
you
was that an error of law?
Yes, because you start out at the categorical step 1. And if step 1, if there's statutory overbreadth, you then go to step 2 to
Right.
ask whether it's indivisible. The BIA skipped
And
over
Romero,
that.
well,
that
this court's
step.
already resolved that. Romero Milan held that the statute's divisible by drug type. So
Well-
that can't have been an error of law.
No, it is, because then within the drug type, that's where they ignored state of Pequena, which was cited to both the IJ and the BIA. And state of Pequena in Arizona, there the defendant said, hey, you didn't prove whether it was an L isomer or an N or D isomer. And there the state court said, we don't care, because
Right.
all isomers in Arizona are criminal. It does not matter which isomers are involved in your offense.
Sure,
That is
sure,
the
but
error.
are all positional isomers of methamphetamine, were those charged against your client, or was he charged with methamphetamine?
He was charged with methamphetamine. State peak.
But that's, as a statutory matter, that's different than an isomer of methamphetamine, right?
It's the same thing as Lopez Aguilar.
Well, it's
where he
let
was.
me let me ask you this: the definition of dangerous drug is what includes positional isomers, right?
Includes methamphetamine, and methamphetamine includes positional and optical isomer.
No, it doesn't. 133406 C1 is the clause that covers as a dangerous drug the following listed items and their positional isomers.
Which includes methamphetamine.
Right. So the positional isomers are included as dangerous drugs, right?
Correct.
They're not included as methamphetamine, are they?
No, but they are, but
Okay.
it is recognized.
I just want to make sure I had your concession on that. And your client was
Well, Your Honor,
convicted of
it-
methamphetamine, right?
Yes,
Not,
but-
not just charged with paraphernalia of a dangerous drug, but paraphernalia relating to methamphetamine, right?
Well, yes, and under methamphetamine, then it can be indivisible, and that's where state Pequena comes in. And that, when you ask what the error was, the BIA never looked at the divisibility of methamphetamine, and state v.
Well,
Pequena.
how is it statutorily divisible? What part of the statute makes methamphetamine divisible
It's
as opposed to dangerous drug divisible?
It's indivisible because methamphetamine can be defined by positional and optical. The federal definition has optical definition. And what's clear about the federal definition is that under methamphetamine, both under the sentencing guidelines, there's a different sentence and a different conviction about whether the person possesses D-meth isomer or the L-meth isomer.
And both of those are methamphetamine federally, and in Pequena says that both of those isomers are methamphetamine as a matter of Arizona law. But is there any Arizona statute saying that a positional isomer, saying a positional isomer of methamphetamine is methamphetamine as opposed to is a dangerous drug?
Yes, because
Which
under
case is that?
state v.
Which Arizona case is that?
State v. Pequena.
Well, that only dealt with optical isomers.
It said that the state does not have to prove which isomers are involved because
But the
all
optical
of them.
isomer is charged in that case.
No, Your Honor, because as the court explained, all isomers in Arizona are not only regulated, but they have the same sentencing consequence. In federal court, by contrast, D-meth has much higher sentencing than L-meth, which
That's
is
true.
why then in federal courts, the prosecution has to have evidence about whether it was the D isomer or the L isomer. Because as Mathis says, the punishing consequences can prove whether it's an element. We know that the isomers have different elements in federal court.
I'll let you save your time.
You want to save the balance of your time?
Yes, Your Honor. Thank you so much.
Very well.
Okay.
Let's hear from the government.
Good morning, Your Honors, and may it
Morning.
please the Court. Imran Zaidi for the respondent. The question before the Court is whether petitioner's methamphetamine offense in Arizona qualifies as a controlled substance offense for immigration purposes. Now, the parties both agree that the agency overlooked petitioner's argument that Arizona's methamphetamine definition is overbroad because it includes positional isomers, and accordingly that the agency—
You agree that, and I agree that the BIA didn't address positional isomers, but why are you saying that that was an error of law?
We're not saying, Your Honor, that that's an error of law. We're saying that
Okay.
that issue was developed by petitioner below and that the agency, without question, did not examine that evidence.
You
And
previously, as the government, moved to remand.
That's right.
And then in your supplemental brief, you argued that the court could affirm. Are you withdrawing your motion to remand?
We're not withdrawing your argument, and in fact, our central primary argument, even in our supplemental brief, was consistent with our position in our answering brief, which is that we do believe that remand is appropriate here because this
Is
can't
it
be
an
resolved
error of
without
law
fact.
for an agency to fail to address an argument that is not necessary to reach the results it reached?
No, if it's not necessary, and I think
And
even
is that
if
what happened here?
we do believe that it is necessary to understand what positional isomers are in order to
Why?
conduct a proper
Why?
categorical
Was
approach.
Alcacer Vargas charged with paraphernalia relating to a positional isomer of methamphetamine, or was he charged with paraphernalia relating to methamphetamine?
Your Honor, he was charged with paraphernalia relating to methamphetamine.
Right. He wasn't
Arizona's—
charged with dangerous drug, was he? It specifically says methamphetamine.
No, Your Honor, it was just methamphetamine. And
Okay.
you're,
So then why did the BIA have to address any other drug that may have been a dangerous drug at all? Whether it's an isomer of meth or phentermine, which is a listed drug, which happens to be a positional isomer of meth?
yes. So I see that you've addressed some of these other Arizona methamphetamine cases, and that's where the phentermine argument comes from. Our understanding of petitioner's argument is that because the dangerous drug schedule defines meth as part of its general cross-reference in its isomer definition to include optical positional and geometric isomers, that's why
But
those
that's not
are
what
part
the statute says. It says dangerous drug includes the position.
Oh, we agree. We
It
certainly
doesn't
agree
say
with
that meth includes those isomers, does it?
It doesn't.
And he was charged with meth, right?
Pardon me?
Mr. Alcacer Vargas was charged with meth.
He was
not-
charged with meth, yes.
Let me put it this way. If the court were to deny the petition for a review on the basis that I've outlined, would the government defend that? Or if some sort of further review was sought, would you confess error?
I suppose it depends on exactly what the court said. What would
It
that
said
holding
that the
look
BIA
like?
committed no error of law by looking at the Shepard documents to narrow this conviction to methamphetamine, which doesn't have any broader meaning than the federal definition.
We do agree that that is what methamphetamine means, but we don't think that here you can reach that determination without fleshing out what positional isomers of methamphetamine mean. And that's because, and I'm trying to answer your question, Your Honor, I recognize that methamphetamine is listed by itself and that the isomer definition is more broadly applied to dangerous drugs. But those isomer definitions do then apply to each substance, but you need to figure out which of those substances, in fact, have the different types of isomers. For instance, that definition includes geometric isomers, which we know do not exist for methamphetamine. It includes optical isomers, which we know do exist for methamphetamine. So part of what we're asking for on remand is
Okay,
for
but
the
not every positional isomer of methamphetamine is methamphetamine, right? Like one positional isomer of methamphetamine it has a different name that's listed in the Arizona statute. It's called phentermine.
Yes, and it's separately
And
controlled in the
Mr.
federal
Alcacer
schedules.
Vargas wasn't charged with that.
He was not.
So we don't need to analyze whether phentermine is a CSA substance.
Well, Your Honor, this
Can
is
I just ask a
sorry.
question? No, it's okay. I just want to.
I don't wanna leave that hanging, Your
I
Honor.
just want to understand. Your excellent questions are probing what I'm interested in with the government. I find the government's position to be a little inconsistent here. We've got, if I understand it, 3 different cases that have been remanded eventually from our court to do what you're asking us to do again.
That's right.
Which is to have the BIA, or I suppose actually the IJ, the traffic court as you refer to it, do the scientific analysis to determine whether you have a categorical match or not, or whether it's divisible or not. My colleague, of course, has pointed out that we don't even need to get there in order to have a resolution in this case. And yet the government, in at least 3 other cases, has said, send it back. You're asking us to do it again. That seems rather inconsistent to me. My colleague may be absolutely right on point. You don't even need to get there. But what should we do with this now, given the fact you've got 3 other cases sent back to resolve the very same question you're asking us in your original pleading to do?
Well, Your Honor, respectfully, I'm not sure what the inconsistency is. We are asking this court to do exactly what it has done in those 3 other cases, in which the agency, like here, was not able to address arguments regarding the overbreadth
Well,
of
they were.
positionalism.
From my perspective, if this were a civil case, this would be a failure of proof. You simply didn't prove up the elements. But because the petitioner in this case did raise the issue
Right.
before the IJ about the isomers, but somehow this has gotten bollocksed up in some way. The BIA didn't consider it, and yet we're going to send it back. I guess that's the best solution from the government's perspective. I gather my colleague has pointed out a way that you could, in quotes, win, in quotes, without our doing that. Are you now advocating that we do what he has suggested?
I'm not, Your Honor. There's never been our position that you can separate out methamphetamine from the isomers in the way that I believe Judge Barker is suggesting here. We
Okay.
do believe.
It's your case.
Your Honor, we're talking about the categorical approach, and I recognize that it asks us and the courts oftentimes to find ways out, but we're still interested in making sure the law is consistent and right. And so we
Can
want
I
to
do a pivot and ask you
Sure.
about, have you read the Seventh Circuit's opinion in Familia Rosario v. Holder?
What is the petitioner's name there?
Familia Rosario v. Holder from the Seventh Circuit?
I'm not sure, but if you start describing it, maybe
Judge
I will.
Williams wrote an opinion there saying that even if a state statute maybe includes some drugs that are not CSA, if the state statute defines what it prohibits with reference to the CSA drug, that makes the state conviction one relating to a CSA drug. So, as applied here, even if positional isomers are potentially what Mr. Alcacer-Vargas was convicted of, despite never being mentioned in his Shepard documents, which you seem to just overlook. But even if that were the case, his conviction would still relate to the CSA drug or methamphetamine. Are you disclaiming that argument here as well?
No, Your Honor. I mean, that is a version of what we did flag in our brief as the relating to
This was
argument.
the last part of your brief?
Yes, in the answering brief. Yes, we think that the relating to argument, at a minimum, must suggest that if you are comparing a substance in a state schedule to the same substance on a federal schedule, then regardless of how those substances are defined by their isomers, then that must relate to that substance. And to be very clear about this argument, Mullooly, which petitioner raises here as suggesting that that does not apply or as having foreclosed this argument, Mullooly, without question, does not address that argument. Mullooly was a very specific and different argument that the government had raised, that just a general overlap in substance schedules can be enough, but that there does not need to be a specific link to the federal substance.
Right.
That
But
is
if
what
that
we-
argument would show that there was no error of law, are you still supporting remand for reasons of the Chenery Doctrine? Are you saying the BAA needs to decide that first?
Yes, Your Honor, and I think the way that we framed it in our position here is that fact-finding would be the first way to resolve this, because we might not even need to get to the relating to argument if positional isomers don't exist, which is still on the
if the
table.
relating to argument's right as a matter of law, you don't need to get to the fact
That's
finding.
true. That's true. It's a which comes first, Your Honor. I think we
And
would.
Chenery applies to issues of law like that? I mean, if we said the BIA did not make a mistake of law, but for a different reason, you would view that as requiring a remand under Chenery?
Well, again, it depends on what the specific question for the BIA to reconsider would be. I think
Your
separate from-
relating to argument.
Right, and I think separate even from the factual finding piece of this, we also asked for remand on that. So our position was, upon remand, after whatever factual findings are conducted, if the relating to argument becomes relevant, that we would like the BIA to be the one to address that first, of course, recognizing that this is a statute, an immigration statute that the BIA administers. And so this court has recognized that
What do you do with the fact that we, as a court of appeals, don't have jurisdiction to, if you will, rule on matters that the BIA did not consider? How does that impact our analysis in this case?
I mean, that's part of why we believe remand is appropriate here. There's, of course, an exception for that for pure legal issues where you don't have a matter that is within the board's expertise. So the relating to argument, for instance, the board did not rely on that here. And we would say that though it's a pure legal argument, it is one that falls under the board's interpretation of a statute it
You think we
administers.
would have jurisdiction to decide this case based on the related to language?
Jurisdiction? Yes, Your Honor. I think we think the board
I think
would...
the BIA considered that enough for us to have jurisdiction?
No, sorry. My point is that you would have jurisdiction because it's a pure legal issue, but my point is that it would be one that the board...
Even if the BIA didn't consider
Even
it?
if the board did not. It's a pure legal issue, but our point is that the board, we
I
believe
thought
the board
under-
should get an initial shot at interpreting it because it is a statute that it administers. But we do believe that the court has jurisdiction to interpret statutes. Even under Chevron, that could have been, and other courts have resolved the
The
relating
former
to...
Chevron?
The former Chevron.
Departed.
Courts, even under a Chevron framework, prior courts have looked at the relating to meaning specifically and resolved it without getting to step two. Just said, we know how to interpret the words relating to. We're just saying that the
You
board
need
should
to
do
go
that
for a
first.
sale on the Loper Bright.
Pardon me?
You need to go for a sale on the Loper Bright.
Counsel, I thought under Chenery that we are only allowed to rule on that issue if the BIA has no discretion to rule on it, so that it's a harmless error if there's no choice but to go one route by the BIA. That's my understanding of Chenery.
Your Honor, my understanding is that if the board had discretion, it was never, I don't believe it was even presented here. So for that reason alone, I think, and again, it's just like the factual findings here. We are talking about issues that both the immigration judge and board never even had opportunity to address.
Right.
I guess what I'm saying is it is a little bit complicated after Loper because we're not talking about a Chevron deference scheme, but this court has continued to recognize, of course, as Loper Bright itself did, that the agency has experience and expertise.
Yeah, I'm not talking
to
about
offer
the merits of the question. I just thought you said that we could, if the BIA doesn't reach a legal question, we can. I don't know if that's true under Chenery, but
Right. Yeah. It does depend on the question, and we view this as a matter of pure statutory interpretation. That, of course, does not. This one involves facts, but the relating to argument does not.
Right.
And I think,
And can I ask one other question? So is the government's position that positional isomers do exist or do not exist?
Your Honor, we are not in a position to answer that based on the record before this court, and I want to address
Yeah,
this
and then what's
directly.
the BIA, the prior decision of the BIA, is that not binding? Apparently.
It's not, Your Honor, respectfully, I think it's the Felix Figueroa decision, which was actually, I think, earlier this year. There, the BIA actually did not seem to follow what this, and that was, I think, arose in the Ninth Circuit as well. It did not follow the approach that this court has counseled in cases like Rodriguez-Gamboa, which is they said if there are overbroad isomers, then you need to you apply the realistic probability test regardless. If that had been the approach in Rodriguez-Gamboa, it would never have come out the way that it did. It would have just said even geometric isomers, which don't exist, end of the ballgame if you can't satisfy the realistic probability test. So no, we don't believe that the board's position there on positional isomers or anything else, it governs in this case. We think that the board needs to follow what this court has done in Rodriguez-Gamboa, which is to say when you reference isomers in a statute, you need to determine the significance of those isomers before you can conduct a categorical approach.
So I gather the government's position remains you want us to remand to the BIA and presumably to the IJ to make scientific findings, get input from both sides, and then ultimately decide whether it's categorically matched or whether it's divisible, whether there's a modified categorical analysis?
That's right, Your Honor. That's the primary argument. We believe for all the reasons we pointed out in our answering brief that remand is appropriate.
But
Now,
can I just ask as a matter of process, your motion to remand was filed some number of years ago. This is still the current position of the government? It's not just you're reiterating the position from a number of years ago?
It is, Your Honor, because we briefed the case earlier this year and made many of those same arguments. And, of course, a lot has happened in the isomer world from when that motion to remand was filed in 2020 and now, but our general position remains the same and what this court has continued to follow since
Do you think the
Rodriguez-Gamboa.
fact-finding before the BIA is constrained by evidentiary standards, or do you think the BIA would essentially be doing finding as to legislative facts as opposed to adjudicative facts?
I believe it would be adjudicative facts, and to be clear, it wouldn't be the BIA. It would be remanding to the immigration judge to conduct that fact-finding and accept more evidence. And we do 100% believe that that is necessary to consider positional isomers. And one of the things we haven't talked about here is it's not just a question of whether positional isomers of methamphetamine exist. It is, because of this Arizona statute, also the question of even if they do exist, whether they have a potential for abuse associated with the stimulant effect on the central nervous system. And I will note, since I want to catalog what our arguments are. So yes, Judge Smith, primarily remand for the purposes outlined in the answering brief. I just mentioned the potential for abuse. That does, we believe, give a route to affirming under the realistic probability approach because, and I see that my time is up, if I can just finish this answer so the court's aware of how we want to proceed. This court flagged the Federal Analog Act. We do believe it provides an alternate route, which would be, because the Arizona statute, even including positional isomers, I understand, Judge Barker, you think that it does not, but even though it includes positional isomers, it cabins the meaning of that to those with the potential for abuse associated with a stimulant effect on the central nervous system.
We've let you go a little bit. Let me ask my colleague whether either has additional questions. All right, thank you for your
Thank you, Your
argument. So, Ms. Hong, you have a little bit of time, and please address the related to issue, if you will, please.
Yes, Your Honor. Then I have 4 points. Starting with related issue, Malooey makes clear that related to applies to drugs that are defined on the CSA. The second point, which does not include positional isomers, Felix Figueroa answers the question of what is the definition of Arizona's definition of methamphetamine. At 158, Arizona's statutory definition of a dangerous drug includes isomers of methamphetamine, whether optical, positional, or geometric. And then it cites to the Arizona statute. The second point, looking at Felix Figueroa, the BIA would have stopped right there for the Second and the Seventh and the Eighth Circuit and said that this statutory overbreath would have ended it. At footnote 2, it remanded this question not for fact-finding, not for evidentiary questions, but for the realistic probability. And in footnote 2, it says the only reason we're doing this is the Ninth Circuit stands alone and has not overturned Matter Ferreira when it comes to drug offenses. The 6 other circuits have done so. So this can be it should be a very easy legal question that other circuits follow.
You're a fan of those other circuits.
I'm a huge fan of the others.
I
I'm
thought
also
so.
I'm a fan of the Ninth Circuit, too.
There you go.
Especially when it is aligned with
Especially
the reasoning.
when it agrees with you.
Exactly.
Indeed. Let me ask my colleagues whether they have additional questions. Thanks to both counsel for your argument in this very interesting case. The case of Alcocer Vargas versus Bondi is submitted.
Thank you, Your Honor.
Thank you very much for your argument.